Assalamualaikum and good day to Saintsfa. My name is Siti Aisyah binti Muhammad Khaira Anwar. Today, my group and I will be presenting about the case analysis regarding damages. So I will be presenting about the part for introduction. So remedies are the legal means to recover a right or to prevent or obtain redress for a wrong. Remedies for the breach of contract is the legal solution to such problems. The exact remedies available depend upon the severity of the breach. If there is a fundamental breach or breach of a condition, the remedies are severe, whereas the remedies for the breach of an ancillary term are not as onerous. There are 4 types of remedies available for breach of contract, which consists of damages, specific performance, injunction, and quantum meruit. The part that we're going to present today is about damages. So damages is the most common remedy granted by the court in cases of breach of contract. The term damages refers to an amount of money that the court orders a defendant to pay to the plaintiff who has proved his case against the defendant. The award of damages is the common law remedy for a breach of contract. The purpose of damages is to compensate the victim for the loss caused him by the breach of contract and not to punish the party in default. Every breach, whether serious or not, will give an innocent party a right to claim for damages for all losses suffered as a result of the breach. The law of damages is provided in Section 74 of Contract Act 1950, which embodies the common law rule of remoteness inherently against precedent. In Section 75 of Contracts Act 1950, it provides for liquidated damages, where parties have agreed on the sum payable as compensation upon a breach of contract. In the classification of damages, there are 3 types of damages discussed in this assignment, which consist of substantial damages, exemplary damages, and nominal damages. Substantial damages or compensatory damages are damages awarded in respect of the actual losses suffered by the claimant. Their purpose is to compensate the claimant for pecuniary and non-pecuniary losses. Meanwhile, nominal damages are granted to the plaintiff when there is a breach of contract by the defendant, but the plaintiff suffers no actual loss or fails to sufficiently prove by loss. Nominal damages usually consist of a small sum of damages. And the third one is exemplary damages. Exemplary damages are also known as punitive or vindictive damages, which are awarded against the defendant in tort as punishment for riding roughshod over the rights of the plaintiff. The purpose is to put the plaintiff in the position he would have been if the contract had been performed. The defendant's conduct is relevant. That's all for my part. Now I'm going to pass the floor to the next presenter. Thank you.
I'm going to be presenting the part regarding to classification of damages. Damages are a remedy granted by the law unto a party who suffers damages, loss, or injury due to the breach of a contract, and damages aim to put the plaintiff in the position they would have been if the contract has been performed or had the contract not have been performed. We have 3 types of damages I'm going to be explaining about. We have substantial damages, nominal damages, and exemplary damages. Regarding substantial damages are damages that bring about an actual economic loss, and the compensation is supposed to be substantial amount, which is awarded as distinguished from nominal damages, which we're going to get into later. Substantial damages actually are economical in nature. They actually refer to an actual loss of the party who suffered the breach of a contract. So the case that we used was the Balbir Singh, Anat Laki, Karam Singh, and others against Senthil Raya Sendirian Berhad. In the case of nominal damages are actually a contract remedy that is minimal and otherwise token amount of money that a court would award the plaintiff when in breach of contract has occurred. Still, the actual financial loss or harm suffered by the plaintiff is negligible or challenging to quantify. These damages are only symbolic in nature. So these nominal damages are only the court's way of acknowledging that essentially nominal damages are just the court's way of acknowledging that a wrong has occurred to the wronged party, like a breach of contract have occurred. Therefore, they are entitled to some sort of damages, but usually this is minimal and just is a way of acknowledging that a breach did happen. We can. In the case of exemplary damages, now exemplary damages are also known as punitive damages, and they're a whole different special category of damages. They're not primarily aimed or intended to compensate a plaintiff or to be a token by the court, but they're instead awarded as a way of punishment towards the defendant for performing something particularly egregious and a wrongful behavior, and this actually deters similar conducts in the future. These damages are awarded over and over, any compensatory or nominal damages, and they're relatively rare in contract cases. They're usually not awarded, but it's usually the main intention of exemplary damages are to punish the defendant for committing a grievous act. Okay.
So, in this complex world of contract law, the principle on remoteness of damage plays a vital role in order to claim damages or loss for the aggrieved party. So, let us observe into the essence of this legal concept and its application in determining compensation for breach of contract. So, for an innocent party to claim damages, they must first successfully demonstrate that the defendant has breached the contract, which causing loss to the innocent party. However, the crucial part to note is that not all losses incurred by the plaintiff are automatically under the responsibility of the defendant. As mentioned in Section 74 of Contract Act 1950, it's provided that where a contract has been broken, the party that suffers by the breach are entitled to receive compensation that has caused him, which naturally arose its usual cause, or the parties knew when they made the contract as a result from the breach. So, this specific section strengthened the use of this legal principle of remoteness, as this test of remoteness of damage is only will be used when the facts of the case were not satisfied by the court to make judgments. So, a landmark case that illustrating this concept of remoteness of damage is in Hadley and Baxendale. So, here the judge Alderson highlighted two linked tests for remoteness of damage. The first one is direct losses and next one is consequential losses. So basically, direct losses are the losses that are fairly and reasonably regarded when the parties agree to enter into the contract. Meanwhile, consequential losses are losses that require the actual knowledge of special circumstances that are unusual but were communicated to the defendant or known by other parties. So, let us see one example of decided case in Malaysia that applied this principle. In the case of Ikubina, Sdn Bhd and Mensa Merserta Limited, it provides a vivid example on this remoteness of damage. So, the appellant agreed to sell the respondent 24 units of heavy construction equipment. After the agreement was entered, the buyer resold 15 units to sub-buyers, leaving 9 units unsold. So, on the date of delivery of the goods, the vendor failed to deliver the goods to Ikubina. So, in this case, the court emphasized that the correct application of damages principle, they set aside the damages for loss of profit and opportunity and recognize the limitation imposed by the remoteness of loss. Basically, to sum up, this principle of remoteness of damage serves as a crucial factor in shaping the scope of compensatory damages as to provide fair judgment both to plaintiff and defendant.
Move on to the mitigation of the loss and focus to the principle used to claim damages, but in this case where the damages will not be rewarded as the loss is too remote. In a situation where an innocent party does not try to mitigate the loss, they are not entitled to recover any loss or damage under the law, which made them unable to recover damages or any part of the loss, which if he could have avoided it and have taken reasonable steps to do so. The general principle is that the innocent party has duty to mitigate the loss. Mitigate is where the act of reducing the severity, seriousness, and painfulness of something. This principle of mitigation of loss damages is portrayed in the explanation of Section 74 of Contract Act 1950. There are three main principles to mitigate the loss, which are: the first, the plaintiff will not be able to recover the damages for the avoidable losses it should have been avoided. Second, the plaintiff avoided loss of damages are not recoverable for the loss. And third, money spent in mitigation or attempting to mitigate the loss is recoverable. This legal principle of mitigating loss is derived from the case of British Westinghouse, where a plaintiff have a duty to take reasonable steps to mitigate the loss for a breach of contract. In this case, the defendant sold faulty and inefficient turbines to the plaintiff, which used more coal. The plaintiff accepted the turbines and used them but reserved their right to claim damages. The
first principle is that the plaintiff cannot recover damages for the losses which they should be avoided. This means that the plaintiff cannot claim damages for any losses that might have been prevented if he had taken reasonable precaution. This concept has established in the case of British Westinghouse, in which the court declared that the plaintiff had obligation to take reasonable steps to reduce the damages sustained. Furthermore, the plaintiff can never sue the losses that he might have averted. A reasonable step is very subjective and it's difficult to pinpoint exactly the constitute is a replacement contract occurs when the defendant offers an offer to the plaintiff in which the amount of damages can be decreased if the plaintiff accepts the offer. The second principle of mitigation is that if a plaintiff would have prevented of loss, damages for that loss would be not recoverable. The case of British Westinghouse against Underground Electric Railway Court of London exemplifies this rule on averted loss. In this case, British Westinghouse supplied the defendant railway business with 8 steam turbines that turned out to be flawed in design and utilized the excessive amount of steam. The Railway Corporation did not reject them, but instead reserved its claim for breach of contract damages. So the issue is whether the railway firm may sue British Westinghouse for the expense of rebuilding the turbines. Okay, next, for the third principle of mitigation, under the rules of mitigation, is that when a plaintiff spends their money in mitigating the losses of the attempting to mitigate the losses, he may be able to recoup his investment. To recover the amount of money spent on mitigating, the plaintiff must prove that the action he takes in mitigating or seeking to mitigate the losses is reasonable. Each circumstances requires of different acceptable steps. What is a reasonable step in one circumstances may not be in another. Reasonable in the regular course of business simply means reasonable. In other words, the plaintiff is not needed to do any special action outside of the normal course of business. I would like to summarize the two principles. Alright, when the plaintiff is mitigating the losses or attempting to mitigate the losses, the money spent on doing so may be recovered. However, the money can be recovered only if the action taken to reduce the losses were reasonable. What defines the reasonable behavior is very subjective and may vary from situation to case. As previously noted, reasonable action in mitigating losses is dependent on the facts of the case, and if and only if the action taken is reasonable, the plaintiff may recover the money spent in mitigating the losses experienced as a result of the defendant's breach.
Next, for the case review, our group chose the case of Kerajaan Negeri Terengganu against SKKPJ Sdn Bhd and another appeal. This case is an appeal case from the State of Forestry Department of Negeri Terengganu as an appellant and the SKKPJ Sdn Bhd as a respondent in the Court of Appeal of Putrajaya. In the judgment of this appeal, the parties will be referred as they were before the High Court, where the SKKPJ is the plaintiff and the State of the Government of Terengganu is the defendant. Both parties, the fact of the case is the both parties entered into a causation agreement for the extraction of timber and forest production in Tambak and Petuan, Terengganu, Malaysia. In the agreement, the plaintiff agreed to pay RM265 million for an 8 years concession to the State of Government of Terengganu. However, this contract was terminated in a mature period by Government of Terengganu. In this case, the first core issue is should the plaintiff claim for his loss of profit as a result of the contractual breach by the defendant, or if the plaintiff only can claim the actual loss suffered by him. In this case, the High Court took the important step of evaluating the nature of the agreement by the parties and its breach. The act of terminating the agreement before the expiry period by the defendant date 15 January 2002 for 8 years was terminated on 15 August. The court agree with the plaintiff that the breach of agreement may give rise to damages for loss of profit pursuant to Section 74 of the Contract Act 1950. A support in this case where the judge referred in the judgment of Zainun Ali, where the general rule of the assessment of damages for breach of contract is that the aggrieved party is to be put in the same position as they would be if the contract had been properly performed. so that normally he is entitled to recover from the contract breaker his loss of profit. The court held that the deprivation of the performance of the concession agreement, which was premature terminated by the defendant after 6 months, was entered into within 7.5 years from the expiration period. Therefore, the court agreed with the Learned High Court judge that the plaintiff may also be entitled to claim damages for the loss of profit. Secondly, the core issue for this case is whether the plaintiff is entitled to loss of the revenue under the concession agreement solely for subblock A or the full the concession area. In this case, the plaintiff is not satisfied with the decision of the High Court because the plaintiff loss of profit is not limited to subblock A but covers subblock B and subblock C, which is the entire concession area 41,000 acres. This is because the plaintiff has paid the lesson for all 3 subblock. However, the court awarded the plaintiff RM 12 million plus for work done by the plaintiff in subblock A. It is because the GPNT had only issued 1 license for the plaintiff to carry out logging activities in 1 subblock at subblock A, and not the entire subblock from the total 41 acres of the land. Hence, the court of the appellant dismissed the appeal from the respondent because they agree with the decision of the High Court, which is without a license from GPNT, plaintiff will not be able to perform its duty and obligation under the agreement, even though the plaintiff paid for 3 lessons by the defendant.
Now, for the analysis, there are 2 main points discussed in this, which is the rationality of damages granted and suitability of damages as a remedy. So, for the first one is rationality of damages granted. In the case of Kerajaan Negeri Terengganu and SKKPJ Sdn Bhd, damages were granted to the plaintiff due to a contractual breach by a defendant. The court's decision was based solely on the losses and costs incurred by the plaintiff resulting from the premature termination of the contract by the defendant. The learned judge's decision to grant damages was affirmed by the Court of Appeal judges by unanimous agreement, emphasizing that in this context, damages were appropriate in upholding the rights of the innocent party, and other remedies like specific performance or injunction were unnecessary. The focus was on compensating the plaintiff for the financial impact of the breach rather than compelling the defendant to perform specific acts. Second is suitability of damages as a remedy. In this case, damages would be the most suitable remedy as they represent a foreseeable and calculable monetary value. Damages aim to put the plaintiff in the position they would have been in if the contract had been performed. Specific performance, injunction, and quantum merit were deemed unsuitable considering the nature of the breach and the adequacy of damages as a remedy.
So now I'm going to present about our last part, which is the conclusion. In conclusion, damages play a crucial role in contract law as they provide a means of compensation for the injured party when a contract is breached. Damages are designed to put the non-breaching party in the position they would have been in had the contract been performed as agreed upon. There are various types of damages, such as compensatory, consequential, nominal, and punitive, each serving a specific purpose in addressing the harm caused by the breach. While the goal of damages is to compensate the injured party, it is important to note that they are not intended to punish the breaching party. The amount of damages awarded will depend on factors such as the nature of the breach, the extent of the harm suffered, and any mitigation efforts made by the non-breaching party. Based on the case of Kerajaan Negeri Terengganu against SKKPJ, TM Sdn Bhd, it provides valuable insights into the principles and implications of damages in contract law. The court's decision highlights the importance of ensuring that compensatory damages adequately compensate the injured party for their loss, while also avoiding overcompensation. The case demonstrates that damages are aimed at putting the injured party in the position they would have been in had the contract been performed as agreed. The court carefully considered the loss suffered by the plaintiff, taking into account factors such as the cost of rectifying the defective work, loss of revenue, and other foreseeable losses. Furthermore, the case emphasizes the requirement for the injured party to mitigate their loss, meaning they must take reasonable steps to minimize their damages. The court acknowledged that the plaintiff had indeed taken steps to mitigate their loss by engaging an alternative contractor, but also considered the additional costs incurred due to this mitigation. Another crucial aspect highlighted in this case is the limitation on damages. The court recognized that damages cannot be excessive or punitive. In determining the quantum of damages, the court must strike a balance between compensating the injured party and discouraging windfall or excessive compensation. Overall, this case reinforces the importance of carefully assessing and calculating damages in contract law. It serves as a reminder that damages should be proportionate to the loss suffered, with a focus on compensating the injured party rather than punishing the breaching party. By considering all relevant factors and principles, the court aims to achieve a fair and just outcome in contract disputes. That's all from our group. Thank you very much.